Oh, do I?
Hello, everyone. This is Tyler Crone with the Thundering 36. We are so delighted this afternoon to be interviewing and in conversation with Ian Burke, who is running for our Washington State Supreme Court. Over to you, Ian, to introduce yourself.
Thank you very much. My name is Ian Burke. I'm one of your appellate judges at the Washington State Court of Appeals, and I am running for Supreme Court position 4. Um, just a quick update on endorsements. Since I last addressed the 36th, I think what I've added since then of some significance is the Aerospace Machinists Union, District Lodge 751, has endorsed me. As has the 32nd District Democrats and Indivisible Tacoma, and also yesterday, Attorney General Nick Brown. So all that's very exciting. I was appointed to the Court of Appeals by Governor Inslee in 2022. At the court, I've written over 200 appellate opinions. They touch kind of every aspect of life in Washington, all across the state. I'm also very proud to be endorsed by appellate judges from all across the state who collectively represent more than all 39 counties. That's 30 current and former judges of the Court of Appeals. I spent 20 years as a lawyer where I represented individuals and small businesses taking on typically more powerful interests in insurance denials, workplace discrimination, and consumer protection. And I was a volunteer lawyer at the King County Bar Association Legal Clinic in Lake City, where I worked with consumers facing debt issues and tenants facing housing insecurity issues. All of that shaped how I see the law. I see it as something that has to work and be accessible for everyone. And I'm running to ensure that we keep politics out of the court and that judges decide cases based on fact and law, that we uphold equal access and accountability and integrity. Um, and I'm glad to be here.
Thank you so much. Joanna will ask our first question.
Should I wait till the clock goes down?
I think
Um,
Amanda's going to reboot it. There we go.
okay, great. So, how would you approach cases asking to overturn longstanding judicial precedent, especially for cases that were decided long ago when Washington State looked differently than it does now?
Yeah, so we use the incorrect and harmful test. And what we're really doing is we are balancing, on the one hand, predictability and settled expectations versus, on the other hand, ensuring that the law will be current and meet the needs of today, as opposed to only those of the past. Um, and, you know, it has, the first thing we have to look at is just the reasons that were given back then. I think I'm one of the only candidates in the race at all for whom this is not an academic question, because as an appeals court judge, I have written appellate opinions that have overruled past decisions of the Court of Appeals. And the first thing we need to do is we need to ask what were the justifications given and do they really bear scrutiny? And including, do they stand up to scrutiny given changed conditions today? Kind of the other side of the coin of the incorrect and harmful test is we'll also revisit decisions when the assumptions they were based on just don't really hold true. Um, one of the big ones that has led to cases being overturned in recent years has been a recognition of kind of who wasn't in the room when a lot of our older doctrine got established. For most of Washington's history, in order to be a justice on the Supreme Court, you had to be a white male. And not only you're actually kind of discouraged in some ways from looking at the world through a lens other than your own. So that has led to a lot of situations where if all we do is simply broaden the kind of sets of considerations that we look at, a lot of the old assumptions just don't justify some of the older decisions. But that's what we're doing. We're looking at the reasons and we're asking ourselves, can we give persuasive, better reasons today?
Thank you so much. Anita?
Artificial intelligence, or AI, is not always a well-defined or understood term. How do you define AI, and how do you think the court should approach using AI in day-to-day operations?
Yeah, so I'm not going to accept that invitation. I'm not going to try to define AI myself because I don't believe that a legal person has the qualifications to do that. But I looked at some other efforts to define AI. NASA's got one on the internet, and so does IBM. And kind of the core of it is computers simulating human decision making, kind of decision making traditionally invested in humans. And I think the key word there is simulating, because AI has promise if it's used in under supervision. Um, I think where it has a particular promise is in helping us create kind of complex, repetitious documents that we create in court, where there's great potential for error. At the moment, probably the thing that stands out is our protection order calendars. We have 6 different kinds of protection orders that we issue in Washington courts, and therefore a very complicated form of order. And I like to think that AI can help us spot things that aren't done that need to be done, for instance, in the moment. It also has great potential for helping pro se litigants issue spot and determine possible legal theories, which is the kind of core things that lawyers do, and what AI in electronic legal researching has helped lawyers do better for years. The catch is all of it has to be under supervision because, I mean, when I represented individuals, for instance, I used to spend a lot of time trying to help people understand what the court is looking for in the first place, which is, just not what a lot of people necessarily assume. I'm going to go over time just a sec here, if that's okay. Um, it, because, I mean, if you don't kind of have a background understanding of why our laws are what they are, it's not obvious, why you need to be talking about this as opposed to that. I would like to see AI improve that. I'm a little concerned at the moment that the people who create AI maybe also don't understand kind of what we're trying to accomplish in court. But there's promise if it's used with supervision. And the last thing I'll say before I really do stop is I think it's a mistake to anticipate that this will bring a sea change quickly. I think it is much more likely to find incremental to incrementally help if carefully deployed in case by case situations. So I think it's important to have the right kind of attitude for any new tool that has the potential to help but might not.
Thank you. Joanna?
The Harvard Crimson recently reported on an emerging two-track clerkship system aligned on ideological grounds with a distinctly different path to clerk for liberal versus conservative federal judges. How does ideological alignment impact the work of a judge, and how can we create and protect a nonpartisan bench? Since electing judges is an inherently political endeavor, how do we ensure that judicial races do not become de facto partisan?
I have so much more than 2 minutes to say on this subject. Uh, but that was a really interesting article. I'm glad you guys flagged it. So first off, let me start by saying that 99% of what we do inside the court is nonpartisan, just completely nonpartisan. That said, ideology enters into it. I think it enters into it kind of typically in the willingness of the judge to see a particular issue that's brought to us as a legal problem in need of redress. So, we saw at the US Supreme Court, Voting Rights Act got eroded again today, or again this week. And, the 15th Amendment guarantees the franchise without abridgment due to race or color. And it gives the Congress the power to legislate on that subject. I think what we see in the Supreme Court is just a fundamental difference over kind of what rights were vindicated by the effort of the Civil War and the Civil War amendments. So that's an example. In terms of partisanship, the races are looking more partisan. The Salman Jia and Dave Larson race looked pretty partisan, and I think these will too. But I think that masks a false equivalence. Because, as the Harvard article pointed out, what's really driving that is partisanship inside the judiciary, recruiting first-year law students, which is just very remarkable to me because, kind of the premise of that recruitment is they don't know, they don't, they're brand new law students. The only thing that we know about them is that they're committed conservatives, and that apparently is the qualification for recruitment, as if they already have all the answers that they need, which just sounds very wrong to me. I got to go over time again. I'm so sorry. Um, but what I'll say two more things about that. One, in recruiting my own law clerks, I look for perspectives different from my own. Not so much politically, we don't even think about that really, but walks of life. I want people who have walked a different life in this country than I have, so we see different perspectives, in part because what I now know is that appellate law clerks are our future judges. The last thing I'll say, and this is what my takeaway from the Harvard article was, we talk a lot about kind of the structural protections of democracy, like electing members of the House every 2 years and senators every 6 and presidents every 4. That's a second line protection. The number one protection of democracy is to do what you guys are doing right now, which is to think carefully about who we put in these positions. Because that Harvard article really described bringing partisanship to the judiciary and doing it from within. And that's just very alarming to me. If we want people who are committed to nonpartisan decision making, we need to have people in the jobs who have that commitment. There's so much more to say on that topic, but I'll stop.
Thank you so much. Our last formal question will be from Anita.
Tell us a little bit about continuing education requirements for judges, and how do you proactively seek out furthering your knowledge and understanding of bias, diversity, inclusion, and accessibility? How have you applied these to your work?
I remember when Washington introduced the requirement for continuing education for judges. It was an 8-to-1 vote by the Washington Supreme Court. Justice Richard Sanders dissented from that. And I have pursued this most aggressively in 2 areas. One is appellate writing. So I attended early on, I attended a week-long seminar at NYU that's been going for 60 years on appellate writing that has state and federal appellate judges from all across the country. And the other is diversity, inclusion, and accessibility in the judiciary. Most recently, I spent a week in Montgomery, Alabama on learning about strategies to eliminate racial biases from the courts. And kind of the biggest takeaway from that is a recognition. We talk a lot today about implicit bias, and that's a serious problem. What we talk less about, frankly, is a long legacy of explicit bias that was written into our laws themselves. And so, in terms of applying it, I would say I apply it pretty much every day in the sense of, particularly when we're looking at older principles of law and the way they apply today, I want to, I kind of have a level of distrust that I think is necessary. To take a fairly nonpartisan example, Washington has a statute that on justifiable homicide that appears to say that it's a defense if you're protecting yourself from any felony. That doesn't make a lot of sense. I mean, check fraud's a felony. You can't use lethal force to defend yourself against it. It's almost certain that history is from the legislature very early on, trying to make it legal for people to use spring guns in warehouses, literally to use lethal force traps to protect against property crimes. The judiciary has never gone for that. That has never been Washington law as applied in court, but it represents a value judgment I think today we'd find extraordinary in terms of valuing the interests of a property owner over a person on the other side of a burglary. And so I think the big picture is to approach these questions with skepticism of the past when we're trying to figure out what is the right answer in 2026. And that's the big takeaway from what we're trying to do when we look at different perspectives than our own.
Thank you so much. This concludes our formal questions that we have prepared in advance. I'm going to pause here to see if there are any follow-up questions from our board members who are in the room right now. And if there are none, then we'll pass the baton back to you to provide us a more loose follow-up on any question we've asked or a closing. But let me pause here and see if Anita, Joanna, or Amanda have a question for you. Seeing no hands coming up, there were many areas where you said you would love to continue on. We also, invite you to have this moment to just kind of share a little bit more loosely, and we'll say no more than 3 minutes so that we're kind of wrapping up our formal interview on time, but we'll give you back the floor to carry forward with whatever else you think we need to hear. Thank you.
Sure. I would go back to the Harvard article. Another thing I wanted to say about kind of partisanship in judicial elections is it's true that elections are inherently political, but they're not necessarily political in a partisan way. In other words, I think that the electorate recognizes that even though they're voting for judges and that's a political act, they recognize that judges have a different political role in our system than the political branches do. I mean, everyone can understand the need to appear in court and have a judge who will listen to what they have to say, and who will give them a chance to be believed if they're right, and who will do that regardless of who they are, what their background is, or what their circumstances are, if they are right in that moment. I mean, that is what the core of due process is, and I think that the voters can respect that as what they're looking for in judges. I touched on the issue of false equivalence too. We see that in this electoral moment, with Rob McKenna with his PAC about, kind of blatantly pushing the court in a political direction. I read his website and I just see politically right coding all over it. It doesn't, if we have that coming in, it doesn't necessarily mean that anyone else is necessarily looking at it in a political lens, even if they disagree with that. Because it could also reflect the fact that one political party has become a minority party in this state, and they're losing lots of political battles as a result, and including on policies that then end up in courts as policies necessarily do to test for constitutionality. And then the only other thing I'd follow up on is that, in terms of precedent, I wanted to add to the courts have a special responsibility to kind of exercise humility towards their interpretation of the Constitution. When we interpret a statute, if we kind of get it wrong or get off in a bad direction, the legislature can just fix it. I mean, we have a legislature whose job is to incrementally fix things as they arise. The Constitution's different. It's much harder to change, and if we're not careful with it, we create an unintended constitutional straitjacket. Another one of the things that we're defending when we defend the constitutional order is the people's right to self-government and to set their own policy through the democratic course. So we almost have a greater obligation to be open to an argument that we have misinterpreted the Constitution because it's harder to change.
Thank you so much, Ian, for being with us today. This concludes the formal part of our interview, so we'll end our recording.